All right, everyone, welcome to White Collar Week, our Tuesday night speaker series. Our speaker tonight is Doug Berman. I'm going to give you a little background on Doug in a minute, and I have a little housekeeping to do in advance. The first is this is sponsored by our White Collar Support Group that meets on Monday nights at 7 p.m. on Eastern and 4 p.m. Pacific. And it's a community of volunteers and people who come together with a common interest in white collar justice. We've been meeting for 7.5 years. This coming Monday is our 384th meeting. You're welcome to join us if you are directly justice impacted. If you are the spouse or loved one or significant other of someone who's going through a criminal justice issue, we have other groups that are meeting on Wednesday and Thursday nights. And feel free to reach out to us. All our contact information is on our website at prisonist.org. And it's prisonist like feminist.org. And we will direct you. We find a resource for everyone who dials into us. So thank you for that. Just a few announcements. The first is, and I just want to make sure I've muted everybody, so I apologize. The first announcement is on November 14th, for our speaker series, we're going to have a town hall on fairness and restitution. So there's going to be 4 speakers or 3 speakers and a moderator. And they're going to be making a presentation on remissions and fairness, specifically in the federal justice system. But I think there's also some state issues in there that they're going to be talking about. We get a lot of information. There are people from some major organizations, including the Ladies of Hope Ministry, and I think from some other organizations that I can't think of right off the top of my head. I apologize. But it's in the emails and it's on the website and everything. So please, and I will put a link in chat later where you can register for that. Also on November 2nd and 3rd, the American Bar Association Criminal Justice Conference will be in Washington, D.C., and that's free. So for anybody who's interested in these type of topics or in criminal justice from a legal standpoint in general, come on down. It's at the Madison Hotel. You do have to register in advance, but it is free. So last year we had 14 of us attend, and 14 members of our support group attend. And then we all went out to Carmine's and had a great Italian dinner after that, and a lot of hugs and meeting people who we only knew on Zoom, a lot of us. So it was great to see each other. So there's our housekeeping. Let me introduce Doug. Let's see. We are honored to have Doug as our speaker tonight. Doug is a law professor at Ohio State University, and among many things that I think he'll talk about in terms of his background, the way that he is come to national attention, at least to my attention and to many practitioners' attention, is through a blog he writes called Sentencing Law and Policy, and it keeps us all up to date. Practitioners and criminal justice people, keeps us all up to date on the status of sentencing. And so we reached out to Doug when we knew we wanted to do a webinar and a presentation around some of the big issues that are now face a lot of white collar folks, but a lot of other folks too, nonviolent and violent, around new guidelines from the U.S. Sentencing Commission and some other things that have happened in the court system, notably in the the 3rd and I want to say 3rd and 11th for how to calculate loss. So this could be all good news for us in terms of leniency and mercy in the court system. Of course, everything comes with strings in our system. So Doug's going to tell us all about that. So without further ado, Doug, please take it away. And afterwards, we're going to have a Q&A section. So when Doug's finished, please put your names in chat and I will call on you. So Doug, it's all yours.
Thank you so much, Jeff, and thanks to all of you for attending. I'm inclined, especially because probably the average age of this group is at least a little bit older than the average age of my students, to talk a little bit of my origin story, since it's years that will not be before you were born, like it is with some of my students. But I had the good fortune after law school to clerk for two different judges on the U.S. Court of Appeals for the Second Circuit, and this was relatively early in the guidelines era, certainly the mandatory guidelines era. This was the early 1990s, when I had a chance to clerk for then Chief Judge John O. Newman of the Second Circuit, and then Judge Guido Calabresi. And then after that, I went to practice for a couple of years. And during that time, I got connected to folks who were involved with the Federal Sentencing Reporter. And it's a journal that I now help edit that I highly recommend. We've done a number of issues on white collar topics, and it's really what got me most involved in kind of the day-to-day engagement with the federal sentencing system, especially after having clerked at a time when those issues were sort of first really starting to occupy the circuit judges and the rest of the federal judiciary. And then I knew when I went into teaching that this was a topic I was going to be interested in. And I think, and probably all of you think, that sentencing has always been a really, really important issue. But it was kind of a niche issue around the time that I was saying I wanted to teach a course on sentencing in law school. And I was very fortunate that Ohio State was open to that idea to let me develop my own course in sentencing. And as I did that and really came to understand just how rich and important all these issues were, I got connected to a number of other academics and co-authors. And we put together a case book called Sentencing Law and Policy. And I especially love the fortuity of this. We were, this was in early 2000, expected to do a website along with that case book. And I said to my co-authors, websites are kind of boring already. They're static. Wouldn't it be great if we did this newfangled thing called a blog, and we could update the website in a kind of a regular way that would help teachers? It would be a terrific resource in that way. And my senior colleagues, who were older and wiser and still are, said, that sounds like a great idea. Why don't you go do that, Doug? And we'll work on other things because we're plenty busy, and that sounds like a lot of work. And I'm like, all right, I'll see what that's like. And then fortuity of fortuities, I started playing with the technology, and then literally launched the blog a month before the U.S. Supreme Court issued its landmark ruling in Blakely versus Washington. And that was the case that was the precursor to Booker, which I assume this group's fully familiar with, that turned the guidelines from mandatory to advisory. And I really do think, a lot of my career has been just very fortunate to be in the right place at the right time. And so started blogging pretty regularly at that moment, and had lots to talk about when the guidelines became advisory and all the debates over what that might look like. And it's somewhat hard to believe we're now almost a full 20 years since the guidelines became advisory. And it's one part of the fascinating backstory of the world we're in now, which is that judges have been sentencing under advisory guidelines longer than they ever sentenced under the guidelines as mandatory. And even though that provides some additional equity, some additional justice in the work that judges can do day to day, I'm sure you're all familiar, the guidelines still play this major role in shaping and determining the fate and outcome of individual defendants. And of course, the white collar guidelines, the fraud guidelines in particular, but many of the others that also can apply to white collar offenders, I think are distinctly severe and create their own sets of headaches and problems that have, I'm sure you're all aware, been widely criticized and yet still remain in place. Against that backdrop, among the things that's been so interesting for those of us who follow this field closely over the last 5 years or so is the guidelines had been kind of stuck in what I called in some writings jurisprudential amber, because there was not a functioning sentencing commission for almost a full 5 years. That was largely a product of President Obama not able to get appointments through, or really not making appointments in order to ensure there would be a working quorum continuing all through the term after he served. Then this was not a priority for President Trump. He made some nominations in 2018, but those were not politically viable. He then made some more nominations in early 2020, or late 2020 actually, but those were too late in his term. to have any traction once he didn't secure re-election. And it wasn't until early 2022 that President Biden made his appointments to fill up a commission that had been completely emptied by that point. And there are some practitioners, certainly an academic like me, who took a nice deep breath. It was in some sense useful to have a pause in the work that the commission did and have the same guidelines in place without all sorts of yearly changes. However, I say that against the backdrop of what had been the norm for really the entire modern era of the federal sentencing system, under a guideline regime, which was that the commission was largely a force for severity rather than reform. That an awful lot, especially in the early days of the commission, even in the mandatory system, there were many amendments that were about limiting judicial discretion to depart. Often when there was a circuit split over the interpretation of a guideline, the commission would adopt a more harsh interpretation. Some of that was influenced by the fact that the one bold, more lenient move that the commission tried in the 90s to reduce crack sentences to be equal with powder sentences got rejected by Congress. The only amendments that ever have gotten rejected and overturned through the congressional process for doing so. And so the commission was seen by many. I certainly know, talking to a number of public defenders, other defense lawyers as like, they were very much of the mind when the commission was out of business because there wasn't a quorum. Oh, that's just fine with us. We don't look to the commission as a source of relief or opportunity for our clients. They've always been a force to ratchet up the severity of the system. And I give that background because I think, before getting into some of the specifics of what the commission did in this latest amendment cycle, and we'll get particularly into the criminal history details in a few minutes, I think it's important to put it in context of what I sense is the first commission, though a split commission, really a 4-3 commission, because it's a bipartisan. It has 4 Democrat appointees. It's got 3 Republican appointees. And so far, although there's a lot of nuance to the story, it's been the Democratic appointees who have been more driven to push decarceral reforms. But we have a commission that I very much sense is interested in not just doing better, but doing better by being more lenient, by shifting our thinking about sentencing generally, particularly the functioning of the guidelines, to be far less punitive, or at least to do what they can to move the system into greater balance. And that's obviously not just for white collar offenders. That's for the wide range of offenders. But I think understanding that and knowing that both enables one to kind of understand what's afoot with current reforms that are, I think, beneficial to both current prisoners and future defendants, but also thinking about what's possible in the next amendment cycle. Now, important point, even though there's a new commission and it's got 4 Democratic members, administrations change and commissioners change. And so there may be a particularly limited window in which we can predict that this commission is going to be interested in what I'll call decarcerative type reforms. And there's a broader political context, of course, that what they feel like they can do, what they're willing to try to do, is framed by a number of political and social factors. And so I wouldn't expect too much, although this is what's so interesting. What they've already done and what has gotten them a lot of, I shouldn't say a lot of attention, but has gotten some attention is itself noteworthy. And I actually think the criminal history rules that I'll talk about is actually an even bigger deal than some of the other amendments that have gotten more attention. And that's itself another piece of kind of understanding of how the law and policy is going to move forward, that there are very technical things that the commission can do that can have profound impact, that will fly a little bit more under the radar than some other things that may be higher profile and may get some more pushback, but that in its own way may distract attention from the more consequential reform. So what am I talking about here? I'm specifically talking about the 2 highest profile changes that the commission made, partially as a result of the First Step Act, and then more generally about its own recidivism research. And so what's that about? First, some of you may be aware of, probably, lots of talk about compassionate release. That's the colloquial name for the authority that after the First Step Act is in the hands of prisoners to file for a motion for a sentence reduction under certain circumstances, the commission is tasked by Congress to explain what these certain circumstances are, or more accurately, what can qualify as extraordinary and compelling reasons to allow for a reduction in sentence. That's been the highest profile sort of point of debate in the commission's work, largely because there was a debate in the circuit courts before the commission was reconstituted, and that will continue because the Justice Department is going to keep pushing it, whether or not a change in the law, and specifically the most salient one here is the way in which the First Step Act changed the most severe gun mandatory minimums, whether defendants who, some of whom literally got 100, 150 years because of mandatory minimums, now would only be subject to maybe 10 or 15 years under the new law, should be able on that basis alone to get their sentence reduced under the compassionate release rules. And the circuit split on whether that's a proper reason. The commission weighed in, and this gets to my decarceral notion. The commission weighed in on the side of the more pro-prisoner, pro-defendant approach to this issue, namely saying, yes, a change in the law can, under certain circumstances, though they limited the circumstances, be the basis for a sentence reduction. 3 of the 7 commissioners, all the Republican appointees, objected to that and said, among other things, they didn't think the law allowed that to be a reason for a sentence reduction. The Department of Justice seems to have embraced that thinking, and it's likely that this is going to be litigated even after the commission's new guidelines come into place, and that's going to be very interesting to watch. That's going to be something that I suspect will get a lot of attention. It's something that's going to be important to a certain class of current prisoners already serving a long sentence that would be helped by certain high-profile changes in the law. But realistically, there's probably only at most 1,000 or so. I'm spitballing here. It could be a little bit more than that. Could be a lot less than that. That rule will impact, and that's unlikely to impact a lot of future cases for a range of reasons. Though again, the basic rules of compassionate release certainly matter to lots of defendants. What is so much more impactful, both for future cases and for current defendants or current prisoners, is the change in the criminal history rules. And so that's what I'll really drill into. That's what I'll focus on. And there's lots and lots of parts to that. One that is actually in front of the Supreme Court right now, though on a statutory question, relates to the statutory safety valve and how the criminal history rules should be understood for allowing somebody to get the safety valve to go below a mandatory minimum. There aren't that many mandatory minimums that apply to white-collar offenders, though there's the aggravated identity theft, and there can be all sorts of other ways that other mandatories could be implicated, even in white-collar offenses. But I won't talk at length about what is truly a debate over whether the word "and" means or means "and." And if that interests you, I'm happy to talk about it in the Q&A. It's going to be interesting to see how the Supreme Court resolves that question. There's a parallel guideline amendment that is about that as well, and so it becomes both a guideline issue and a statutory issue. But the topics that are, I think, much more germane to the day-to-day work of courts going forward, and particularly for non-mandatory minimum case, are the changes in what's generally called status point offenders, and especially changes in what is now being called 0-point offenders. And though on the surface, I'm inclined to assume, and I think the data bears this out, that the 0-point offender amendment is of biggest interest to white-collar offenders, because there often are persons with no criminal history who may qualify for that change in the criminal history rules. But I was looking at the commission's data, particularly their data about the retroactive application of the status point change, and their data seem to show there may be hundreds of current prisoners for fraud, theft, and other white-collar offenses that would also benefit from the status point change being retroactive. And let me talk about both changes in the context of what drove the commission to make these changes. The commission has done, to its great credit, an extraordinary number over the last decade or so of recidivism studies, where in the simplest of terms, those studies have really proven up the virtues of the criminal history score and the guidelines approach to ramping up sentences based on increased criminal history. Long story short, if you've got a lot of criminal history, the commission's data shows your odds of recidivism are extraordinarily high. And if you have almost no criminal history or no criminal history, your odds of recidivism are really, really low. And that's both heartening to know that our existing sentencing rules sort of map on to dangerousness relatively accurately, though again, there's all sorts of nuances to that. But what those studies showed in a more detailed way was, first, there are lots of people who get additional criminal history points because of their status. And by status, it means they're on probation or parole from a state sentence or supervised release in the federal system. And in addition to all the other criminal history points they might get for earlier offenses, there's kind of a double counting that would take place if they were still on probation or parole when they committed their latest offense and are being sentenced in federal court. And what the commission data shows was that extra status point really didn't predict recidivism very well. And there was very much a racial skew, a range of other skews based on who's subject to being under criminal justice supervision more. They're going to get these status points more, even though it's not clear the recidivism data supports giving them longer sentences. And so the commission wrote a new rule that basically eliminates status points entirely for lower level offenders and cuts them in half for folks with more criminal history. And that's already complicated. It's even more complicated because, of course, those of you really familiar with the guidelines know having a higher criminal history points doesn't matter unless it pushes you into a new criminal history category. So what really matters is whether the change in rules changes your criminal history category. If it does, it can be quite impactful. If it doesn't, it's kind of a wash. And the commission has predicted that there are, at least looking retroactively at the current prison population, perhaps about 11,000 folks for whom the new criminal history status point rules could make a difference in their guideline calculation and they would be eligible for a reduction. This was voted to be retroactive. And so that's a pretty big category of folks. Again, 11,000, a lot bigger than the people who are likely to get compassionate release or anything more are going to get a reduction if judges decide through the retroactivity process, which requires an application and a judge to conclude that public safety is reasonably served by giving folks this reduction. But that's a big chunk. And again, I think there's a not insignificant number of white collar offenders who may have a chance to get a lower sentence based on the status point change. The other one that's, I think, even more likely to impact the white collar community, but also is really going to impact a whole range of different offenses and offenders, involves the 0-point offender idea. And what that's built around is, again, the commission's recidivism studies show that there are people who end up in criminal history category 1, which is the lowest category, but have 1 criminal history point. And their recidivism rate is actually a lot higher than somebody who's still in criminal history category 1, but literally has 0 criminal history points. Now, that doesn't necessarily mean 0 criminal history if you have really, really old criminal history, which again could be quite relevant for an older white collar offender, somebody who did something as a teenager, then stayed out of trouble completely, and then in their 40s or 50s committed an offense. They probably would still score up as a 0-point offender because of the aging out of their minor criminal history in the past. And so it doesn't really mean no criminal history. It just means no points of criminal history under the guidelines rules. That person, now here's my favorite part of what always makes life hard and complicated. I would think the right thing to do would be to create a criminal history category 0 for these 0-point offenders. But the commission, I think, perhaps understandably, didn't want to rewrite the whole chart that, is the bane of everybody's existence and trying to figure out where they map onto the guidelines chart. So instead, what they did is they said, if you're a 0-point offender, you get a 2-level reduction in your offense level. So whatever else the offense calculations add up to, if in addition you qualify for the 0-point offender category, you'll then get a -2, kind of like you can get 2 or 3 for acceptance of responsibility or some other ways in which you can get 2 levels down and it goes to your offense level score. Qualifying as a 0-point offender does that. Now, an important point, and I got to make sure I get the language exactly right because it's a key component of how this functions. The commission, I think, mostly for political reasons, but I think they would say also for reasons supported by their research on recidivism and the like, created a whole bunch of carve-outs for who qualifies as a 0-point offender based on the nature of the offense. So the most obvious example of this is the guideline says the defendant did not receive an adjustment under the terrorism guideline, or the defendant did not use violence or credible threats of violence in conjunction with the offense. And those are factors that, again, I think there's some evidence-based justification for saying those aren't 0-point offenders, but I think more so it was driven by the commission's sense of, we don't want to give this break to every first offender. If they're a terrorist, if they're involved in a very violent offense, we want to carve them out. Most of the carve-outs relate to violent offenses, weapons offenses, civil rights offenses, and so may not apply to most or even any likely white-collar offenders, except, and this carve-out could be potentially significant, and I think is going to have to be significantly litigated. The defendant did not personally cause substantial financial hardship. So let me repeat that one with all of the not quite elements of the offense, but I'm teaching first-year criminal law to my students, and I tell them to break down every word. The defendant did not personally. I think that's quite significant because I think the idea is if you're involved in an offense, but somebody else is sort of the main person driving the fraud bus, so to speak, you could argue, oh, no, I don't get that carve out because I wasn't personally. And then, of course, it's personally caused not any financial hardship, but substantial financial hardship. And ultimately, that has no fixed meaning. That is not something that's clear, has any history into the guidelines. That's going to be something that's going to have to get litigated. And I suspect will get litigated pretty aggressively because I would think in a lot of white collar offenses, the Justice Department's going to be advocating for a 0-point offender. No, sorry, you don't qualify for the 2-point reduction because you personally caused substantial financial hardship. And so that's like, so much of the guideline is going to be up to a judicial finding. And it will be interesting to see if, as I expect, some jurisprudence develops around that. Key point, the commission also made this guideline retroactive. And I think we may end up seeing a lot of that litigation through debates over retroactivity, right? Because those carve-outs also apply to 0-point offenders seeking 2 levels down as they're already in prison. And so that issue, maybe other aspects of what will be the other carve-outs that are there. The other big one that is also potentially subject to quite a fight and that might be quite relevant to white-collar offenders is a very freighted final one that says the defendant did not receive an adjustment under 3B 1.1 aggravating role and was not engaged in a continuing criminal enterprise. And already there's uncertainty about, wait a minute, that's all written into one of the carve-outs. Does that mean you have to be a leader and involved in a continuing criminal enterprise in order to be carved out of the 0-point offender reduction? Or are those 2 separate criteria so that if you got any kind of aggravating role adjustment, and I know that happens for more than a few white-collar offenders, then you're completely out of the 0-point game. And again, I suspect that's going to end up being litigated at great length in the retroactivity discussion. Among the things that's going to be fascinating, maybe the wrong word, but for a nerd like me, it's fascinating, is the commission has data for both the status point amendment and the 0-point offender amendment. Let me get this date exactly right because I pulled up their calculations recently. They think there could be as many as 50,000 current federal prisoners. That's about a third of the federal prison population that has at least an argument that they could benefit from the status point retroactivity, though they then calculated that only about 11,500 of those folks actually should be eligible. And for the 0-point offender amendment as well, they calculated that 35,000 folks may be eligible or think they're eligible for 0-point reductions, when in fact they calculate that only about 7,250 are actually eligible. And so it's not just a story of, those are big numbers to begin with, right? Basically, it adds up to about almost 19,000 offenders who the commission estimates are eligible. Again, that's roughly speaking, about 15% of the federal prison population, that they all would get reductions. Again, the reductions wouldn't mean immediate releases for some, but that's a pretty huge swath of the federal prison population potentially getting reductions from these amendments being made retroactive. But you look at the numbers for who thinks they might be eligible, it's literally half the people in federal prison. And of course, that not only is interesting because it's going to be a lot of work to sort out who's eligible and who's not, who gets the benefit, who doesn't, but it also suggests to me that, roughly speaking, about half of the defendants going forward are potentially going to benefit from these new criminal history rules. That's my way of saying these are huge changes that can impact dramatically guideline ranges and then probably ultimately sentences for a whole host of offenders across the board. And yet very few people are paying attention to this other than groups like this that are able to sort of drill into this. And that's what we're going to see in the coming weeks is these officially become law as of November 1. Last important point about the retroactivity piece of the story is that the commission said nobody can have their reduction effective until February 1, 2024. So they're creating this sort of 5-month window in which we can litigate over who gets a reduction, but nobody actually will get out until that time. And there's a lot more intricacies to all of this, but I want to make sure we have time to talk about the loss issue, because this is another issue that the commission has got its eye on. And it's another one that I think creates a kind of technicality that the commission, if so inclined, could do something very bold on, but it remains to be seen if they will and how they will. And this relates to a very nerdy issue, if we haven't been nerdy enough already, relating to administrative law and the deference that courts are supposed to show to the guidelines commentary. And this has become an issue not just with white-collar offenses and loss under the fraud guideline. It's become an issue with the career offender guideline, which has commentary, which seems to expand who's a career offender. It can also come up in some other guidelines as well, although not quite as robustly or as impactfully as it does for the career offender guideline and for the loss issue. But here's the basics of the issue. All the guideline says is that you're supposed to calculate loss as part of calculating the guideline range. Then the commentary to the fraud guideline says, well, when you're calculating loss, use the greater of actual loss or intended loss. And I'm sure many of you are familiar with, or certainly we could talk at length about how, I'm tempted to say, pernicious that instruction is, because this means in all sorts of cases, some that include pretty questionable behavior, often by government agents, if they can allege, oh, well, you didn't actually hurt anybody, you didn't actually take anybody's money, but you intended to take millions of dollars. And how do we know that? Because, we sent an undercover agent to tell you, hey, I've got this scheme to take millions of dollars. Do you want to do it? And you say, sure, sounds like a great idea. Aha, we've got you for millions of dollars of intended loss, even though nobody was ever harmed and nobody could be harmed. That's one of many ways that intended loss was often used to inflate the guideline range. And as I trust you all know, the loss calculation is so central and so determinative into a range of the white-collar outcomes. And so what a number of circuits, but not all of them, have said is that's a made-up thing in the guidelines. The guideline itself says loss. The sensible definition of loss is actual loss. And the commentary saying it means either actual loss or intended loss is an expansion of the guideline that we're not supposed to show deference to anymore after some Supreme Court cases kind of signaled don't show deference in a bunch of other distinct administrative law contexts. And so this has been one of the most interesting and kind of intricately valuable arguments that have been developed by a variety of white-collar offenders in a variety of settings. Some other things that come up in the commentary, the case out of the Sixth Circuit that I know that was one of the first to grapple with this issue dealt with a case of credit card fraud, where a woman was involved in a scheme of skimming off or creating, 10,000 credit cards. And she only ended up like charging, before she got caught, like $2,000 on all those 10,000 credit cards. But there's a guideline commentary that says treat each credit card as if it's worth $500 if there isn't any loss. And so for her, it was 10,000 cards times $500. Oh my God, there's $5 million of loss sort of made out of thin air, when in fact she only actually created a couple $1,000s worth of loss. And the circuit said, no, I don't think we're supposed to show deference to that. That's a made up rule in the commentary. The commission is fully aware of this, and they're struggling to figure out, well, what do we do? They're struggling in part because some other circuits have said, no, nothing to see here. This is fine. Commission commentary is a little different, and all those administrative law things that everybody's fighting over in other areas, that doesn't apply here. And so one level the commission's struggling with is how they should weigh in on this sort of dispute. More than a few cases have tried to bring this to the Supreme Court. The Supreme Court hasn't yet shown interest in it. And one wonders whether they're waiting for the commission to act or the commission's waiting for the Supreme Court to act. But if the commission were, in a sense, to basically strike out all of its commentary, saying we understand this is no longer stuff that courts are supposed to follow, and the commentary that we think is really important, we'll try to reenact into regular guidelines, that might give them a new kind of opportunity to move the guidelines in a more positive direction, which I think, again, a majority of this current commission is inclined to do. Now, that's a very big job, and that's a very big job that can cause all sorts of headaches if they try to do it, for all the guidelines. I'm sure this group would say, start with the fraud guidelines and fix those and fix them to make them not so loss dependent regardless. And that's the other problem here is I do think this commission is highly attentive to criticisms of the entire guideline system. But, it's a little bit, like the old joke about, how do you eat an elephant? Well, one bite at a time, right? How do you reform this really elaborate, very imperfect, really very problematic federal sentencing system? I think they're approaching it one bite at a time. And that's where, again, I'm so far optimistic about how they're chewing, so to speak, to keep the metaphor going. But obviously for individuals who are facing the current structures of the system, or particularly, a judge that's inclined to be very pro guideline and follow, even the most severe calculations, that can be cold comfort that we're not taking down the entire elephant, as quickly as possible. But that's a little more than 30 minutes, but I tried to cover lots of ground there, Jeff, and hopefully lots of ground that was interesting. I see Gina's asking, and I'll start with this question, does actual loss amount change if monies were recovered by a receiver? A very good question. And I think, again, a question that the commentary speaks to a little bit. And importantly, this is part of the broader story of course, all of the guidelines are still advisory. So what one judge could do, if so inclined, even if they're not supposed to calculate loss with intended loss, if they're in a circuit, again, the Third Circuit has one of the most interesting recent decisions. Banks is the name of the decision from late last year, kind of addressing this issue square on. A judge in the Third Circuit still could say, okay, I know I'm only supposed to use actual loss, but when I actually calculate the loss for this offense or that offense, it's so low, I think that understates just how much was intended by this defendant. And that's a 3553A consideration, the nature and circumstances of the offense that leads me to want to go above the guidelines or, otherwise follow the guidelines when I might not otherwise. And so that's, of course, the broader story. I definitely think even calculating actual loss is subject to lots of debates and lots of circuits. And so I can't speak to timing would matter a lot on that as well. But definitely in all sorts of settings, litigating over loss is even more important now that there are these precedents that throw shade, so to speak, on the commentary, which is mostly where a lot of the fraud guideline action happens.
So, Doug, first of all, thank you for that incredible presentation. And we're going to get to everybody's questions in a minute. When Doug and I spoke this afternoon, just to set this up, one of the things I think we agreed upon was that it's important to get the information out there. Not every practitioner is as up to speed as to the current status of the U.S. Sentencing Commission and what it could actually mean on the ground, and who should be arguing what in terms of their sentencing memoranda and things like that. And as mostly end users here on this call, and who will be watching this on video, we have to be educated consumers and make sure that our lawyers and experts and everyone who's involved in advocating, at multiple levels, whether it be plea or at the probation, at the PSI or in the 3553A and the sentencing memoranda, everyone is arguing the best case possible for you, regardless of where in your circuit or in your courthouse or in your judge it happens to be at that particular moment, because things are changing. So this is all information that, please, if you want to send the link to your lawyers and say, watch Doug Berman, this is the state of the art as of today. Important stuff. Along that vein, I'm just going to ask a couple of questions and we'll open it up to everyone, because it seems like we're coming out of a time period where there was a lot of actual leniency, maybe not sentencing leniency, but certainly leniency in terms of time served inside prisons because of the CARES Act and the First Step Act. And I don't know how much empirical evidence has been produced because of those early releases, but it seems to me that somewhere I've heard that that at least one circuit is considering Zone D split sentences, and if that's true, I mean, what it could mean. I'm going to rely upon you to explain what I'm talking about better than me. But what that could mean potentially is arguing for a split sentence, which means part of the time in prison, part of the time in the community, but with a special condition for home confinement. And therefore, that's kind of a really cool way for a lawyer to do like an end run around if the prosecutor and or judge will go for it. So what have you heard about that? And do you think that tactically that's something that is on the horizon and we should be talking to our lawyers about?
Yeah, I mean, so I'll actually, I didn't drill into this, but I'm happy to do so at great length here. One of the things that I think is motivating the current commission, and it wouldn't surprise me at all because I think the staff of the commission and the commissioners themselves are out talking about the importance of alternatives. And your point is spot on, that one of the things I think driving that and driving it in a positive way was that the CARES Act releases into home confinement, other elements of the First Step Act have been perceived very positively. There's very imperfect and very, I don't want to quite call it non-rigorous, but incomplete data on recidivism of folks released early to home confinement that are really, really good and kind of support advocates saying, look, what we've proved out during the COVID era is we could safely release a heck of a lot more people to serve their sentences at home rather than in prison. And especially at a time, and this is something that, we're talking about resources a little bit earlier with respect to a conference that took place last week, the Bureau of Prisons is strapped for resources. Literally, they don't have enough guards, and they have, other workers improperly serving as guards because they're so desperate. My sense is the resource constraints is not only sort of getting known, but it's this combination of, even though the current federal prison population is significantly reduced than what it was 10 years ago, it's still way too high and unsustainable relative to the resources, relative to the staffing, relative to the challenges the Bureau of Prisons have. And we've proven that releases to home confinement can be relatively safe. And hopefully we can keep doing that by making good arguments to judges. Hey, this is the kind of offender, whatever zone they're in. And, the zone's backstory is there are all these commission explanations for if your guideline calculation puts you in a certain zone on the chart, you're not supposed to do a split sentence or an alternative, and that you're only supposed to do an alternative for these very low level folks. I suspect the commission is currently reevaluating even those guidelines. And this is part and parcel of something that I left off, but is worth highlighting in conjunction with the criminal history changes, particularly the 0-point offender changes. The commission also had a new application note in its guideline application section of Chapter 5, basically saying if you're a 0-point offender, judges should be encouraged to consider alternatives to imprisonment, right? And that's itself a rarity historically for the commission to encourage something other than prison. And that's what they're saying in some of their policy guidance. And of course, this, they say, is directly responsive to a provision in federal law that's largely been ignored, which is 28 USC 994J, which was its instruction to the commission. I'll read it directly. The commission is to ensure that the guidelines reflect the general appropriateness of imposing a sentence other than imprisonment in cases in which the defendant is a first offender who has not been convicted of a crime of violence or an otherwise serious offense. And I've always wanted to read that provision as really a presumption against incarceration if you're a true first offender and it's not violent or otherwise serious. One of the problems has been the guidelines have interpreted otherwise serious as, oh, you have enough offense points, then it's otherwise serious. And of course, for fraud offenses and others, the offense points can stack up pretty quickly to make you seem serious, even though I don't think that's what Congress had in mind for true first offenders. And so the commission, I think, is itself very dedicated to giving more meaning to that idea that there are first offenders, particularly for whom the presumption should be something other than imprisonment. And I know their latest statement of priorities for the next amendment cycle is, again, part and parcel focused on what alternatives work, what can we do? Again, there's a resource issue, there are challenges, but that's going to be up to both getting that message out to defense attorneys, to judges, to prosecutors, to probation officers, letting them all know this is not just a commission priority, it's something that Congress called for from the very beginning, and that ultimately is fundamental to what sound advocacy should be about to begin with. Look, if we're not going to make the public safer by having this person incarcerated for the full duration, why not save the taxpayers money and actually increase the likelihood of effective reentry that comes with getting back to the community and starting to rebuild a life outside of prison, with some time to spare. And so, I think it's absolutely something that should be argued really for every defendant in every situation, because prison should be, something that's a unfortunate necessity, not a default.
Thank you, Doug. We're going to go to questions. Let's see. We have Nevin, then Bill, Gina, and Charlie. So Nevin, you're up first.
Professor Berman, thank you for your time and your insight. Is there any case law which the intended loss to the victim, which is lower than the actual loss, is used to calculate the guideline sentencing? And the example here is the defendant commits an alleged fraud, but the money is lost by an unrelated third-party action, like the account is hacked or general market forces caused the loss.
So I love this question, and I smiled so broadly when you brought it up, because I've been involved in making recommendations to the commission through its amendment cycles and things like that. And I've always been a big fan of flipping the or to an and, in a sense, in their current guideline commentary, so that I think it should be let's say it the right way, the greater of, let me say it right. It really should be no more than the greater of intended loss or actual loss. In other words, what you're saying, and I've articulated that poorly, is hey, if intended loss is much lower, we don't hammer the guy for actual loss that really isn't a product of his own intended choice. I think that's sound. I think that's certainly something that I would argue under 3553A as a basis for a variance or a departure. There's language in the actual guideline commentary that says if you calculate fraud to end up with a much higher number than really represents the real crime, right? And that's, again, I can imagine all sorts of cases. You gave one example, but, I intended to use those credit cards to buy myself a nice new refrigerator that cost $5,000, and then I was going to throw them all away, and then somebody else gets them and charges it up, for hundreds of thousands, but not my fault. I certainly think that's a very relevant consideration. I'm not aware of any case, because I don't think it's supported by the current guidelines or commentary, that says we go below actual loss. Again, there are arguments can be made that the defendant's not responsible for that loss, right? And so that's another way to say it's not actually loss that's properly attributed to the defendant. But if it can be attributed to them, then I think almost every court's going to say, I got to use actual loss to calculate it, but go ahead and make an argument that this should be mitigated under a departure or a variance, because this is not connected at all to what the defendant actually intended. There's a broader problem here, and I'll use this as an excuse to promote my interest in addressing this broad problem. So many of the guidelines, not just the fraud guidelines, certainly this is true with the drug guidelines, true with a lot of other guidelines as well, don't give mens rea, something I spend literally weeks and weeks teaching my students about how important it is in criminal law, how central what your mental state is, what you intended. Oh, that's so central to the way our criminal law operates, until we get to sentencing under the guidelines. And now nobody cares. You just calculate the drug quantity. Doesn't matter what you intended or even what you knew about what the drugs were involved. Oh, you just calculate the loss. What was intended is only used to aggravate and not to potentially mitigate. That's a kind of an endemic problem with the way the guidelines and also mandatory minimums function. They fail to give respect to mens rea, though, again, that's the kind of thing that, at least in an advisory guideline system, effective counsel can emphasize why that's so important to bring back into the picture as we're ultimately judging the nature and circumstance of the offense and the other factors in 3553A.
Thank you, Nevin, and thank you, Doug. I think we could bring you back just to talk about the nuances of what real loss looks like, honest services fraud, public corruption fraud, and like what's going on, and is anybody ever guilty of public corruption fraud if you haven't taken money anymore? I don't know any of that. Let's see, Bill.
Hi, Professor Berman. Thank you. I two things. I wanted to tell you that I really enjoyed your panel last week. I thought you did a fantastic job. And my question tonight is, what do you see happening in the different courts, how prosecutors are trying to negate that 2-point reduction for first-time offenders? Because if you remember back when the First Step Act came in, prosecutors were trying different things to prevent someone from getting the benefit of it. What do you see happening, and what have you heard happening in the different courts?
Yeah, I mean, I'm very confident they're going to argue aggressively for a very expansive reading of all the carve-outs, right? So that's going to be, their go-to strategy. Now, I think it's going to be, and I'm sure you're all familiar, that, these become negotiating points more often than not, right? So it's going to be a question of, is this something we want to fight over, before the sentencing judge? Is this something that even could be a fight at the circuit level? Because, there's so much uncertainty about, so many of these kinds of carve-outs. And I think at the end of the day, the Justice Department, at least in cases where they're comfortable with the range, even after the 2-point deduction, won't dicker over the particulars just for the sake of dickering. But definitely, it's going to be another point they're going to want to raise in contesting what the probation office is calculating, in the broader set of stories when there are fights over loss amounts or there are fights over other aspects of the guideline calculation. And I think it's going to be an ongoing challenge for defendants and their attorneys to sort of figure out which fights are worth picking, and what I think we really don't know at all about, right? So I guess this is the nuance of this that I think the prosecutors themselves are going to sort through. The prosecutors are going to be inclined to be aggressively resistant to this new reduction applying to everybody. And again, a little bit of it's trying to be faithful to what the commission said. A lot of it is the more reductions there are, the less power they have to get deals and all of that sort of stuff. But then I don't think anybody knows how the judges are going to approach this, right? Are judges going to be inclined to treat this quite expansively and say, oh, the commission says there's this broad category of people who are getting over sentenced, who have no criminal history. These are just very limited carve outs, and I'm going to work hard not to have them apply. Or are judges going to be resistant and ultimately say, oh, nope, you're technically a leader, and that's good enough as I interpret this provision to exclude you from getting these -2. And so I think it's going to be some uncertainty with how hard prosecutors are going to fight it, but I think they're going to try to preserve as much power. Like you said, we saw this with the First Step Back. We're seeing it with compassionate release. They're just always going to be resistant to anything that brings, you might say, more equity into the system. And then it's really going to be an interesting question of how judges sort this out. And I think there's going to be a lot of circuit need, because defendants who don't get it from a district judge will have all sorts of reasons to appeal. And so I think we're probably going to see, within a year or so, a number of circuits kind of weighing in on some of these issues, and that itself will, of course, then influence how prosecutors approach, how aggressive to be in the litigation.
Thank you very much, sir.
Doug, just to follow up with Bill, we're in our group, we're concerned about things like prosecutors issuing superseding indictments on the courthouse steps to accommodate for the 2-point reduction, or judges who might otherwise be inclined to give downward variances not do that anymore because you're already getting your 2 points. So it's that kind of thing where we want to know where the rubber actually hits the road.
Well, and I can throw in one interesting little nuance that could cut either which way. The commission, in its own discussion, for the reasons they created this 2-point, 0-point offender downward adjustment, is their data showed that for true 0-point offenders, folks who would qualify under the rule, they were only getting within guideline sentences. I think the numbers were like about 39% of the time, whereas people with 1 criminal history point were getting within guideline sentences like 48% of the time. So I think the commission's vision in some respects is give them 2 points off and then judge follow the guideline more, right? That's always where the commission is at least somewhat inclined to want to adjust the guidelines so they're followed more. And again, case by case, that could help some defendants and hurt others, right? A lot's going to depend on just how much of a difference that 2 points makes, and then where the judge lands, whether in the range or outside the range.
Yeah. Thank you, Doug. Gina.
Hi. Thank you for joining us today. I'm sorry, I have to leave for work. So we're 0-point offenders, and I sent probably like a 20-30 minute read from one of my other groups to my lawyer. And she has been under the assumption this entire time that the judge that we have, Judge Bashant, that she was already giving the 2-point reduction when back from like 2 months ago to current. And I sent her this really long article written out, and I said, thoughts? And her reply was this: simple, you are eligible. You will get the 2-level adjustment. Like, it makes me nervous because it seems like there's so much more to this. Like, we're 0 points. It's a drug crime. And she just she's not taking it very seriously, it seems to me, but maybe she's very educated on it and very understanding of it.
Yeah, I mean, that's always the challenge in all of these settings, is she may know, and again, this is where it's I actually have a good friend who's a relatively new judge here in Ohio, and he's like, what are we supposed to do when the amendments are proposed but they're not officially law yet? Are we supposed to apply them now but they're not law yet? I'm like, well, there used to be a time when the guidelines were mandatory, when everybody would postpone sentencing until they became law, and then it would be clear. But now that they're advisory, you can kind of give credit for it now, sort of. And he was saying, rightly so, and this is again where there may be all sorts of complications going on in your case. If you're being really faithful, a good judge shouldn't give that -2 in the guideline calculation until it's law, but they could, and I think should, give it as a variance. Well, a variance is not technically -2, although it can be if you decide to call the variance that. And at one level, this is just semantics. At another level, you're right to want to make sure your lawyer is not just, hey, don't worry, we got this all figured out, just stop worrying. But she may know that this particular judge is one who has decided to operationalize this reduction. And in some respects, a good lawyer knows they need to respect that judge's way of doing things, right? And if you kind of say, well, wait a minute, this is the more technical way you're supposed to do it, rather than this other way, that can create its own sets of headaches. Important point, just to be clear, I think I may have mentioned this, but it's worth clarifying for sure. As of a week from tomorrow, November 1st, this is law. And that's, I don't think Congress was going to reverse it anyway. And that's always where there's a 6-month period to give Congress a chance to review it. Since we don't have a Speaker of the House, and it doesn't look like we're ever going to have one again, I have no worries in predicting absolutely a week from tomorrow, this is law. And so then the judge will be duty bound, again, if you haven't been sentenced yet, to make that guideline calculation if you qualify. Now, it's eminently possible. This is the challenge, and maybe this is not giving direct advice, but, does the prosecutor agree that we qualify, right? That's the one uncertainty, is just to make sure, yeah, the whole team is on board that you're going to get this credit. But if important point, this is where the guidelines are so important. When something is a guideline, rather than just, this is a good argument, the judge has to directly address it, especially if raised by the parties, and rule on it. And so she will have to, after November 1st, rule on whether you get those 2 points off or not. And if your lawyer's saying, yeah, we're going to get it, then you're in a good position. Again, how much you want to make sure that includes the prosecutor agreeing, I'll leave that up to you. But I think you're doing all the work necessary to just, safeguard that she's up to speed, but it sounds like she is.
Thank you so much. I have to leave for work.
Thank you, Gina. All right, we have Charlie, then Kate, then Carrie.
Thanks, Jeff. And Professor, thank you for the clarity of your presentation. I use that word carefully because my biggest concern is that the commission will not be clear. And my issue really rests on the fact that there is a pool of rogue jurists who don't give a rat's patootie about guidelines. They will go through the orchestration and they will do what they want. So we are stuck with guidelines, but the commission's emphasis, commentary, detail will certainly give rise to, I believe, appellate work. And the question that I'm asking is, will there come a point in time where the appellate circuits will basically admonish those jurists that don't respect the law? Because the guidelines are going to be law. It's not like somebody just sent out a bulletin. It is law. So that's my challenge, trying to understand, because it's potluck. Someone can get a jurist that believes that downward departures are essential. And there are some jurists that believe white-collar offenders need to be abused at levels disproportionate to the violent offenders in the federal system. query, will there eventually be a time where the appellate system will put everybody in their place? Again, not as definitive compel, a sentence that has to be issued, but give the guidelines a little more deference than you really are.
So that's a wonderful question, and I could easily spend the next 3 hours, not just 5 minutes, kind of addressing it across a number of dimensions. I very much feel as though appellate review has been one of the failures of our system, that we haven't reined in outliers, particularly in my view, the severe outliers, in the way in which I think the system was designed to do in order to create a more uniform and more just sentencing world. I am hopeful, but not optimistic. How's that for a lack of clarity in an answer? That the Biden appointees, who have been a larger percentage of federal defenders and civil rights lawyers than any other group of judges ever appointed, are going to be attentive to these concerns in a way that the appellate judiciary hasn't been to this date. Among the things that's really interesting, though, and it's sort of the backdrop of a little bit of the history I spoke of, Charlie, and it's again a fascinating sort of component of times they are changing. A decade ago, certainly 2 decades ago, the concern, rightly so, especially among the defense bar, is why won't those circuit judges let at least some of the district judges use their discretion to be more lenient? Why are they so committed to applying the law in such a kind of rigid, defined way, claiming that this is what the system's supposed to be about, and darn it, they don't understand that these judges sensibly see the individual and should be departing, right? That's what the terms then. And that's the, I think, hardcore problem, is not just the relationship between discretion and law in this setting particularly, but also that a commitment to law here at times can be, more often than not, a commitment to harsher law, not a commitment to a guideline system encouraging judges to be more lenient. Though, again, I think there are lots of ways that the extreme severe outlier could get a lot more attention and still allow some of the more lenient outliers to not be subject to the same kind of reversal scrutiny. But I think at the end of the day, you got to keep arguing, you got to keep pushing, and you got to keep hoping you get the right panel. We've certainly seen more rulings pro-defendant in the last 10 years than we saw in the previous 30 of the guideline system. One of the most notable have included some circuit panels essentially demanding that the district court grant compassionate release, which is, clearly meant to be a discretionary judgment. But they've been concerned that judges haven't given respect to a bunch of strong arguments for a reduction in sentence. And so I think there's reasons to be hopeful, but again, optimistic. I'm not quite going there.
Yeah, just as a side note, one of the problems that I see is that the practitioner finds him or herself reporting to the client, your sentence is if it's discretionary and therefore not appealable. And it's the message that is articulated consistently, and in fact, that is not the law. The entire case is appealable based upon the record. But unfortunately, the amount of appeals that are out on sentencing is small, de minimis, and therefore there isn't any reporting or history, while there is very good, not anecdotal, but empirical evidence of the excessive sentencing by a pool of federal jurists. I mean, there's data out there.
I'll frame it this way, and it's just keep it sort of straightforward and simple. I've long thought that there's an opportunity, though I'm not sure circuit judges would seize the opportunity, to build a jurisprudence around 3553A6, right? That's the provision that says avoid unwarranted disparity among similar defendants under similar cases. For defendants who get extreme sentences, you can go to the commission's databases, and they have this new tool called JSON, which would make it even easier to do that and say, look, the commission says the average sentence here is 72 months, and my guy got 240. that's presumptively unreasonable. Maybe if you can get the judge to explain all sorts of reasons why they thought such an extreme upward from disparity was needed, but that's never been. Folks have tried to make those arguments. Courts have generally pushed them away, and there's a limit to how much one can push arguments against bad jurisprudence. But I'm with you that we got to keep tilting against some of those windmills. And again, I want to particularly emphasize that I do think evolutions in the current judiciary provides a basis for hoping we can get some new inquiries. But again, it's a big system with a lot of moving parts, and a lot of circuit judges look at all of this and just say, yeah, maybe it wasn't right, but who am I to say in this one case? And so, good enough for government work, essentially. So,
Well, thank you.
Thank you, Charlie. Kate, then Carrie.
Well, I guess what you see depends on where you sit. So I'm here in the Northeast, and we certainly don't think the guidelines are law. We're glad that they are now officially advisory. They were effectively advisory in the Second Circuit before then, because the government often didn't appeal departures that weren't actually permitted by the guidelines, or the Second Circuit and the First Circuit, for that matter, and the Third Circuit to a large extent, permitted the departures, didn't, interpreted departure grounds broadly. So we're glad they're not law, and I'm glad about a lot of these further changes that are going to be made. But I have a sort of a point that Doug touched on. I think that the judges, at least the judges I'm familiar with in this part of the country, found their way to sentence people what they thought was justly, which almost always, if you look at the numbers, is below, not just the midpoint of the guidelines, is often below the guideline range, particularly in white collar cases, over 50%, because the loss table is so ridiculous. And sophisticated judges know that. And so they use the 553A factors to give a lower sentence. In the last, it didn't happen immediately after Booker, but it's been happening for at least 10 years. So I think, I'm not sure that the 0.20 category 2-point reductions are necessarily going to make a difference, because I think judges were already figuring out a way to sentence below what the guidelines would otherwise have advised, because they're advisory. So I just warn everybody that it's just as when in the old days when we had parole, judges would figure out what the effect of parole is going to be. They're going to serve between 1/3 and 2/3, and they would sentence accordingly. And so if you change the parole rules, the judges are going to change what they're doing. It's a dynamic system.
Mhm.
So that, number one. Number two, I was really interested, Doug, when you said that over half or some huge number of people think that they're going to benefit from the new 2-point reduction. And where does that come from? Because I've read the commission says about 18,000. My final question is, what is the provision of law that allows judges to re-sentence defendants, taking into account the new reduced guidelines that the commission is permitting?
Right. So I'll go in reverse order. Thank you, Kate, so much. It is 3582C2, which is the provision that is an exception to the rule that says you can't change a final sentence, except, and of course, the compassionate release rules is part of that as well.
Right.
You can do so under the compassionate release rules, or you can do so under a guideline that has been made retroactive by the Sentencing Commission. Importantly, you may recall this, Booker doesn't apply to this. In other words, the commission's rules are actually mandatory as a limit to who can get the benefit of these rules. And so, that was litigated with the very first set of crack retroactivity rules. And, among the things that's part of this is for retroactivity, the judge also has to decide the 3553 Act factors support a reduction. And so there's both the are you eligible question, and I'll get to the data in a minute. And then there's the even if you're eligible, does the judge think in his discretion the 3553A factors in public safety support giving you the reduction? And so that's an elaborate set of arguments that individual defendants are going to have to make. The commission has posted on its website a comparison grid that lists who might be eligible. And I think they calculated that by saying, here's the number of people in prison with status points. And that's what's the 50,000 huge number. But
Okay.
having a status point doesn't make you eligible for a reduction, because it has to be a status point that changed your criminal history. It has to be the right kind of status point under the right circumstances. That's where they reduce that 50,000 to 11,000 who they think is eligible under the rule as written. Similarly, there are, I think, 30,000 offenders who have no criminal history, but I think their data there, and this may be some of the status point data too, is like half of them have a mandatory minimum, and so they can't get under the mandatory minimum with a retroactive guideline, and then others don't qualify under all the exceptions or other rules and all of that. And that's where, and I'll be as candid as I can be, if I was representing a defendant who had those other limitations, I might still file and hope, I can make an argument or make some kind of claim, or hope I get a prosecutor who is willing to agree with me that, sure, I get a reduction because get this guy out of my hair, even if I'm not technically eligible. And I think it's going to be a real headache for the district courts as these filings come in and they need to sort through. One of the things, this gets super technical, but I can't help it. As you know, Kate, all the previous sentence retroactivity reductions have all been only for a certain class of offenders. Specifically, they've all been for drug offenders. So we knew for sure if a fraud offender showed up, we'd be like, sorry, doesn't apply to you. Now, these are rules that apply to everybody potentially. You can't just look at the face of the PSR and say, oh, it's this kind of offense, therefore it doesn't apply. It's just going to be a complicated sorting process that, again, I think, and somebody asked in the comments, it's going to be for the public defender's office and the U.S. attorney's offices to try to come up with a list of people they're confident this does apply to, bring that to the judge, try to get the judge to sign off on this, because this is not a resentencing. This is just a sentence reduction pursuant to that provision. It can all be done on paper. And then I guess the hope is we'll all agree to certain ones right away, get those out of the system, and then fight over the other ones. But my understanding is there's like a, not quite a secret list of the commission's numbers are actually with actual cases. Like they actually have case files. They think they know who's eligible. And I've heard stories of efforts by public defenders to ask for the list from the commission, like who in our district meets your criteria. And the hope is those folks can get fast tracked through the system. But it's going to be ugly. I really think it's going to be very messy, including, of course, not to leave out the extra law professor fun here. I think some people who won't qualify for a variety of reasons might try to argue that that's a factor that should support their compassionate release motion, right? And this gets to that changes in the law issue with compassionate release. And so, we're going to keep busy. And I'm fairly confident there are a bunch of people in federal prison from the Second Circuit who aren't going to say, well, the guidelines already did good by me, so I won't bother to file, right? And
No, they'll still file. They'll still file.
Right. So in any event, that's the great questions, and thank you so much for asking.
Thank you, Kate. Carrie.
Hey, thank you for allowing me to come on. I am not a white collar crime person. I am a 841 conspiracy crime, but I am very active in trying to help other people out. So I appreciate you letting me come. One of the questions I have about criminal history is, criminal history is part of pattern as well, and they use the same number. But the problem with pattern and the criminal history is there's no what would you say, recognition for like a significant age difference from the time that this young kid possibly was involved with gang life or something like that and then he got himself clean and then ended up on the wrong side of the law at 55 or 60 years old. All those criminal history points come back to bite him, and it bites him in the pattern as well. So you got guys that are, you know, that have lived a clean life for 30 years who will never be a low in the pattern score. And has commission even considered a grace for age disparity, or not the age that defend it, but I mean the time,
Right.
because pattern does not, and the BOP doesn't.
The commission's guideline rules do have an age out feature. So, and again, that's sort of consistent with best practices of recidivism research that suggests very much so that there is an aging out factor that should be factored into any consideration of criminal history. But you're absolutely right. And of course, the mandatory minimums, other statutory rules don't have age out factors either. And so that's not consistently applied elsewhere. I will say again, to be optimistic, but perhaps overly so, vis-a-vis pattern. Pattern, for those who don't know, is the tool that the First Step Act required creation by the Bureau of Prison with the help of DOJ to create a risk assessment score for every person who's in federal prison. And I sense there are lots of advocates, particularly in the defense bar, who are actively keeping an eye on ugly aspects of pattern and constantly advocating for BOP and DOJ to revise its rules. Among the things in this day and age that gets considerable focus, of course, are racial disparities. And of course, we know that there's all sorts of disparities in who gets criminal history, even if criminal activity is comparable. There are over police communities. There are patterns of enforcement that necessarily lead to different people getting different criminal history that's not fully reflective of actual differences. And so there is attentiveness to that, but the age out issue and a variety of other issues are all ones that are kind of like, yeah, we'll get to that when we get to that, or we work that in to the extent that we can work it in. And I think it's incumbent upon advocates to just keep advocating and keep highlighting these points and keep telling, you know, both individual stories and database stories about why we need to have these criminal history rules constantly updated. And you know, it's something that I sensed, again, 10 or 15 years ago, people were pretty, if not oblivious, at least not nearly as attentive to the way in which criminal history is poorly leveraged to drive severity. And there is, I think, a greater and greater awareness of it. It's fascinating. The Vera Institute has written a report where they basically advocate for just completely ignoring criminal history everywhere, every time. Just it's gone. No consideration of it whatsoever, largely driven by the racial disparity concerns and the fear that it's not a good predictor at all, except of who gets policed. And so, you know, there is a lot of advocacy energy around, let's not give it so much weight, but turning that advocacy energy into actual changes is something that's going to continue to take time, I fear.
Am I correct in the criminal history, in the grid that is in the commission guideline, you know, your criminal history and your score and everything, it's only 7 months per point, is it not?
It's depends on where you are on the chart, I think. And so that's where it can vary an awful lot based on how high your offense level score is. It works, I think the right way to describe it is logarithmically in terms of the increases. Yeah. And so at one part of it, it's not that much. In other parts, it can be a lot. And again, there's also cliffs and thresholds, right? So that if you move up a category, and of course it ends up being influenced by what a judge is going to do anyway. I want to make sure I mention for Lee, I referenced 28 USC 994J, which is the provision that Congress wrote to the commission saying for first offenders that aren't violent or otherwise serious, we're supposed to have the guidelines reflect the general appropriateness of imposing a sentence other than imprisonment. And so that's something I think we're still struggling to operationalize. But with that, do we hope we got all the questions, Jeff? And I'm really grateful.
One more real quick question. Any idea what's going on with it? Yeah.
Carrie, thank you for your question. I appreciate that. Thank you so much. Doug, we're out of time. You've been wonderful. And if it's not much of a non sequitur, I just want to add that as someone who was arrested in 2004 and sentenced in 2006, I had to wait a year to get sentenced because of Booker. And that was also the year that my girlfriend and I fell in love, and she's now my wife of 15 years. So I am particularly grateful to the Booker case for setting up the rest of my life. So,
you know, the love story is much more appealing for all sorts of reasons than the blog story, right? You know, I guess I fell in love with the shine off the blog a little too much for a little while, but so pleased that you know, the Booker a love story will be the very mediocre play we'll write about it, right?
there we are. We want to end on a high note. So, Doug, thank you so much. Really wonderful. I'm getting a lot of texts from people, you know, just telling me how grateful they are and how useful this was. So thank you.
I'm glad I could be a help. I'm so grateful for the invitation. Thank you all for the work that all of you are doing. It's so important that all of you stay, you know, invested in this work. And I'll finish kind of where I started. Among the markers of this commission being, I think, invested in all the right set of values, when they had the retroactivity hearing about these guidelines, they had, for the first time in their history, a panel of formerly incarcerated persons who had benefited from other retroactivity decisions, and they all spoke really, you know, a meaningful statement of how important it is to hear the voices of justice-involved individuals. And, you know, I can say both personally and in terms of seeing this work get done that you know, your voices are heard, and it's just so important that you contribute the important perspective that you can bring to these issues. And so thank you all for what you're all doing. Great to see you. OHIO, go Bucks, and all that good stuff as well along the way for all those so inclined, and hope to see you all again real soon. Good luck with everything. I appreciate, again, the time and the attention.
All right, thank you, Doug, and please join us on November 14th, where we'll be having a town hall on fairness and restitution. And thank you, everybody. Blessings, and we'll see you next time. Thank you.